All right, well, we can begin. Thank you, and hello again. Welcome to our first online Wills Week here at Edmonton Community Foundation. My name's Noel Xavier, and I'm the Director of Development at the Foundation. And I want to thank our amazing group of volunteer lawyers this year. Wills Week brings you 10 presentations, each unique to inspire and guide you in the proper preparation of your estate plans. Now, these plans include not only a will to protect your family, but also your business and your assets, and also 2 additional documents to help you during your lifetime, in case you are temporarily or permanently unable to be as independent as you would like to be. Understanding the hardships and additional costs that occur when these estate documents are not in place correctly will help you to appreciate the value of getting professional help for you and or your loved ones. This week, you'll hear from lawyers about things done well and things gone wrong, how to plan for particular situations like blended families, a family member with a disability, and how tax planning can increase the amounts you choose to give. Edmonton Community Foundation is pleased to provide this Wills Week resource for Alberta-based will and estate information. It dovetails nicely with our usual role as a trusted resource for how organizations, large and small, enhance our lives here in Edmonton and further afield, and how to create gifts that reveal your values in a way that fit for you. So let's begin. For this session, we are very fortunate to welcome Anna May Choles from Rackel Belzil LLP. Since being called to the Alberta Bar in 2012, Anna May has gained a comprehensive experience in advising clients in various legal areas such as wills and estates, real estate, and corporate commercial law. She continues to remain active in both her legal and broader communities and currently serves on the board of directors for the Elves Special Needs Society. She's a co-chair of the Elder Law subsection for the Alberta North Canadian Bar Association. And as you can already imagine, she's a member of the Edmonton Community Foundation's Wills Week. And Anna May has done a number of these presentations for us over the years and is a great friend to the foundation. So I am very happy to have her join us. In her spare time, Anna May enjoys ultimate frisbee and hiking. So I'm going to turn it over now to my friend Anna May to lead us through this presentation. Over to you.
All right, thank you very much, Noel. So this presentation is called Why Get Professional Help with Estate Planning. And so as it suggests, we're going to discuss the role of professional help in estate planning, and that what you're purchasing isn't just the document you get at the end of the day, but it's the advice you're getting through the process, the conversations you're having with the lawyers, the questions that are being asked. That's part of the value of the estate planning process. However, to start off, I'm going to start off with some definitions. Wills and estates can be a little bit jargony, and I just want to make sure that we're all starting off on the same perspective, knowing what certain words mean. So first off, the first definition I'm going to start with is adult interdependent partner. Now, this is an Alberta-specific term referring to a common law relationship that either someone has been in for at least 3 years, or that they've had a child with their partner, or that they have signed an adult interdependent relationship agreement. And this is the sort of common law relationship that attracts legal rights in Alberta, and legal rights for estate planning purposes. The next definition is beneficiary. By that we mean the person who inherits or receives the gifts from an estate. So they're usually the people named in the will. Estate. When we refer to an estate, I'm referring to not to everything that is going to be governed by the will. So certain assets you own, depending on how they're set up, might fall outside of your estate because they're either jointly owned or have a named beneficiary. Or if they're owned in just your name and don't have a named beneficiary, then they would turn to fall into your estate and form part of what we refer to as an estate. Personal representative. This term is more commonly referred to as an executor, but under the new legislation, the Wills and Succession Act, which was brought in 2011, the technical term that is correct is personal representative. That's the person who holds the executor role in probated estate or the administrator role in an intestate estate. So to that end, one of the questions that I get asked quite a bit by clients that I see is what we mean by probate. They hear all the time that wills need to be probated. Well, what does that mean? Probate is the formal process by which you prove a will to be valid in the court. So it's a formal legal process. It's a desk application to which you bring the will to the court. It's reviewed by the court and they said, okay, we're validly considering this to be the last will of the deceased person. So I referred previously to an intestate estate. What do we mean by that? When someone is said to be intestate, it means that they died without having a will. And so that means instead of deciding how their estate was going to be governed, they left it up to what the legislation says. And so it was out of their control. But that's what intestate means. It means the person had no will. So the intestate refers to a person who dies with a will. So then the person who writes the will is called the testator. And then lastly, when I refer to a trustee, we're typically referring to either the person who is administering the trust under the will, or sometimes also the executor or personal representative. Unfortunately, the words get used back and forth a little bit, so it can be a bit confusing. So, starting off to make sure that we're all on the same page, the first question is, what is a will? Well, a will is a document that sets out who is going to be in charge of your estate and how you want your assets to be governed upon your death. So, to that end, there are two major things that you want to see in all wills. Firstly, you want to see the appointment of that personal representative or executor. And then secondly, we're going to distribute the assets in the estate. So that means we're going to give gifts. There are lots of different ways to break gifts up into categories, but broadly, I typically do it by looking at and saying specific gift and gifts of residue. So specific gifts are specific items, specific amounts of money that you're giving to an individual, whereas a gift of the residue is, at the end you're looking and saying, okay, what's left over after we've given away those specific gifts? Okay, everyone gets a percentage share, or these people get a percentage share, or this person gets everything that's left. So what's left once the specific gifts are given, once the debts are paid, that's the residue. And so to that end, you can have gifts of money, you can have gifts of personal property, you can have gifts of different assets. But primarily with those, we're again talking about specific gifts. When we're talking about residue, it's okay, whatever is left over at the end of the day. So one of the major reasons you want to go and see a lawyer or a lawyer to have your will done properly is to make sure that it is in the proper format and it is executed properly so that it actually forms a valid will. In Alberta, a will must be in writing and signed by the testator to be a valid document. So if you had a friend who told you that they promised that you would be in their will, and then at the end of the day they weren't, that's not a valid gift. You can't enforce it because it's not in writing. For a will to be valid, it has to be in writing. So there are two main types of wills that can be done in writing. First one is a holographic will. So what that means is that is a will entirely in your own hand. And I mean entirely. There can be nothing typed, nothing written by someone else. It is entirely in your own hand, signed and dated. Anything else constitutes a formal will. So any will with typing in it, any will written, even printed by someone else, constitutes a formal will, and that is the type of will that requires two witnesses in order to be valid. So you have to sign it, and you have to sign it in front of two witnesses. Now, there are also specific formalities regarding the parties witnessing your signatures and you having to be able to witness their signatures, that everyone is present at the same time in order for the will, for the witnessing to be valid. So unfortunately, we see sometimes when people, maybe they get a will kit, maybe they type something up themselves. We've had a couple of times where either someone has brought in a will that did not have the two necessary signatures, or we had one situation where in talking to the witnesses, it became clear that they hadn't actually seen the person sign the document. They just, someone had brought it to them, said, this is my signature, can you witness this? And they had done that, but it was after the will had been witnessed. And that's not acceptable under the terms of the law in Alberta. You have to physically see the person sign the document, and they have to physically see the witnesses sign the document. So you have to be very careful about those types of signing formalities. One of the other things to be careful about with witnesses is that you want to make sure that your witness is not also a beneficiary under your will. Because according to the law in the province of Alberta, if your witness is either a beneficiary under the will, so a person receiving a gift, or the spouse or adult interdependent partner of a person receiving a gift under your will, and they witness your will, that automatically voids the gift to them. So one of the benefits of doing it in a lawyer's office is you're probably not going to be giving anything to your lawyer in their will or their assistant. And so then you have two nice neutral witnesses who are not going to result in someone not getting the gift that you intended for them. I should note that, however, having someone witness a will does not mean that you can't appoint them. Your witness can still be appointed your executor, even if they're no longer getting the gift in the will. So that means they can do all the work and not get all the benefit. From there, I'd like to talk about a few common drafting errors that we see in wills. So we see a number of wills that are either drafted holographic wills or using will kits, and frequently they have a few issues. So one of the major issues that we see is not clearly identifying who the executor and beneficiaries are. You want to be careful with using names. So sometimes we have families where they have a common name throughout the family. So we might have you might be John Smith, your cousin might be John Smith, your nephew might be John Smith. If you just refer to John Smith within the will, it may not be clear who that person is. So there's other things that the lawyer can do to make sure that we are clearly identifying exactly which John Smith is intended to be the executor, or exactly which John Smith is intended to receive that gift. You also want to do your best to ensure that the names are properly spelled. Because if we can't tell who the beneficiary is, or if you've got several people in one family who have very similar spellings of names and then something's spelled wrong, it can be difficult to ascertain exactly who was intended to receive this gift. This also becomes a really big issue when dealing with charities. It's important that when if you're giving a gift to a charity in your will, that you're giving the proper legal name to the charity. One of the issues that I've run across quite a few times is I have had clients who say, oh, I want to support the Edmonton SPCA. There isn't a legal entity known as the Edmonton SPCA. There is the Alberta SPCA, and then there's the Edmonton Humane Society. There's also various different shelters in Edmonton for animals. So then one of the benefits of having the client come to me as a lawyer is I can sit down and say, okay, so that actually Edmonton SPCA isn't an institution that exists. What do you mean? Do you mean, is the essence here that you want it to go to an SPCA, and so the Alberta SPCA is actually where we want the gift to go? Or is your intention that it goes to an Edmonton-based society for the care of animals, and then maybe the Humane Society or another specific shelter is in fact what you're trying to name there? And so one of the roles that lawyers have is help you specify and clarify, what do I mean? Is how do I properly identify this organization? I've also seen things that happen along the lines of, I saw someone try to give a gift to Sign of Hope. Sign of Hope isn't actually a charity, it's a campaign run through Catholic Social Services. So you want to be careful that you're identifying not just the campaign, but the actual legal entity who you want to give the gift to. And so working with you and making sure that that's clear is one of the important roles that a lawyer does. Another thing you need to consider with your executor is their residence. If your executor or personal representative is resident outside of the province of Alberta, you can run into what's called a bonding issue with your estate. So because your executor lives outside of the province of Alberta, they're not automatically under the jurisdiction of the Court of Alberta. So then the Court of Alberta says, well, we're giving you all of these assets to control as executor. We need some security that you're going to do what we're telling you have to do. And so that means they have to pay in a bond, which is usually about 10% of the value of an estate. Now, 10% is quite a bit. Most people don't necessarily have that to be able to put into the court right away. So even if we say, let's say someone just, all they had was their house. Let's say it's just kind of an average house in Edmonton. Let's say it's a house worth $300,000. If they had an out-of-province executor, that would mean that their executor or personal representative would have to pay $30,000 to the court in order to complete the estate. Most people don't have $30,000 just sitting around to pay into the court for an indefinite period of time. So then the alternate becomes what's called bonding company. So you can pay a company to pay the bond into the court on your behalf. Well, except that costs money, and then that's an expense on your estate that has to be paid. Sometimes if all the beneficiaries can agree, you can get the bond waived, but that's additional time, additional work, an additional cost to your estate. And if you have any minors who have an interest in your estate, the Public Trustee of Alberta, who has an interest in all estates that involve minors, will not agree to having an out-of-province executor, typically. So you want to be very careful that you're naming someone who can actually be the executor and won't cause all these specific problems. You also want to think, if you have minor children, about guardianship. You can name a guardian in your will, and you're naming a person who would be taking care of your children when you're not around to take care of them. And sometimes this is something that gets forgotten, but it's incredibly important if you do have minor children to make sure that you've got that person named, that they're a feasible person, and that you've given some consideration to how taking care of your children might impact their life. If your person you're naming as a guardian is a single person living in an apartment, it may not, we may have to think, you might want to think about how taking on your 3 children might potentially impact their life and how to set up the living situation for that person and their children. And your lawyer can discuss with you the different methods that there can be for dealing with that. We had a client, we've done probates for a number of different types of estates. And one of them was a pretty well done holographic will. So like I said before, that's a will done wholly in your own hand. But there were 2 major flaws in this will. And the second one we'll deal with later. But the first one was that this person gave away all sorts of specific gifts, but failed to give away the residue of their estate. And I've seen this in holographic wills and also in well-kept wills, that people fail when they don't have a lawyer who's assisting them to give away the residue of their estate. And that results in what we call as a partial intestacy. So intestacy means you didn't have a will. A partial intestacy is when you had a will, it just didn't cover everything you had. So that can result in people you didn't intend getting involved in your estate. Under the rules of intestacy, it can be relatively simple if you have a partner, or if you have a partner and children. But if you have a partner and you have children from a different relationship, it gets more complicated. Or if you don't have a partner and children, then gifts go up to your parents, then to your siblings, then to nieces and nephews. And if you didn't intend for certain family members to be involved, perhaps you don't have any children, and your intention was always to leave your assets to your brother's children because you've been incredibly close with them, you've spent lots of time with them, you've got a strong bond, and you write everything else down. You write specifically everything you think you want to go to them. If you don't include a residue clause, suddenly all the other members of the family can get involved, and they have a right to get information and to ask questions, and it makes your estate more complicated because there's been that hole left at the end of the will that we didn't deal with everything properly. Not considering tax impacts of your estate. Different assets that you own will have different tax implications and impacts. And we're going to go through tax impacts a little bit more thoroughly afterward in the next section on another slide. But it's important to know that how those taxes impact the gifts you're giving. Important to note that they can increase a certain gift, or they can decrease a certain gift, or they can mean that sometimes there's no money left for someone at all based on how your estate is structured. And that's one of the reasons lawyers ask questions about your assets. It's not just because we're nosy, it's because we need to know exactly what assets you have, what documents you already have in place and who might have a claim about those assets so that we can deal with them in the proper way and consider all the tax implications of those. To that end, sometimes we also see in documents done without legal advice, people either giving things away twice or not understanding the impact of a beneficiary designation. So, like that, and when I discussed the definition of estate at the very beginning of this presentation, we said that your estate is everything that's solely in your name and doesn't have named beneficiaries. So if you own a property that's jointly owned, so you own it as joint tenants. So joint tenants means you have the right of survivorship. That your half interest in that property will not fall into your estate. It will automatically go to the other joint tenant on your death. Now there's a way to own property tenants in common so that that doesn't happen, but that's a discussion your lawyer needs to have with you. Say, is your intention to own this property as joint tenants? If your spouses or partners, maybe that absolutely is your intention and you want to make sure that yes, everything goes automatically to my spouse right away. But sometimes that's not your intention. Sometimes the intention is no, specifically, we each have had prior relationships, have children from prior relationships, and we want to make sure that our half of the house falls into our own estate. So you want to make sure that that's owned properly. Because if you're giving away assets because you can't give away in a will an asset that's already gone by right of survivorship. So if that house was owned in joint tenancy and you wanted to give it to your children in your will, no, it'll go to who is on title, and that's how that operates. Likewise, beneficiary designations. You can name beneficiaries on any number of assets, on RSPs, on tax-free savings accounts, on life insurance plans, and life insurance policies. But then if there are named beneficiaries, those do not form part of your estate. So you cannot also give them away in your will because you've given them away there. Now you can write your will and overwrite a beneficiary designation on an RSP or a TF or a tax-free savings account or an insurance policy, but you have specific language to do that. And you have to be careful about how you do that. I generally don't like doing that unless there's a specifically good reason why we're doing that, because you can run into situations where you've got one beneficiary designation on the RRSP or the tax-free savings account or the life insurance plan and another one in the will, and this opens up the door to potential litigation. That someone's saying, oh, there was a mistake made along the way, whatever happened last wasn't intended, they didn't understand, I think I should still get something. So now we're just opening the door to additional cost, additional time, and additional expense for your estate and for your beneficiaries. We also have the importance of certain paragraphs in wills. Wills can be full of a lot of legalese, but sometimes there's a specific reason for that. In almost every will that you see drafted by a lawyer, the very first thing they will do is I say, paragraph number 1, I revoke all prior wills and codicils. A codicil is a document that amends a will. So it's like instead of writing your whole new will, you just say, okay, I'm going to change this paragraph. But when we write a new will, we say, okay, we revoke all prior wills and codicils, whether or not our client thinks they have any. We had one estate where, unfortunately, our deceased had a habit of going to the bar and getting a little intoxicated and then writing wills on napkins. And when he died, we found about 3 of them, and they had different beneficiaries. And this caused a lot of questions for the estate. So were these valid wills? Well, you know, he was a little bit drunk. Was the handwriting all his? It was hard to tell. If he was drunk, was this even a valid will to begin with? Did he have the necessary capacity at the time he signed the document to even sign that? And it cost a lot of it was a bit of expense for the estate to try and deal with all these potential claimants who are coming saying, hey, I've got this napkin that was signed. I actually inherit. I get all this stuff. You can layer wills and have multiple wills. So it's important that if you're starting fresh, that you say, okay, I'm revoking all prior wills and codicils, or no, if you're not revoking all prior wills and codicils, that you're specific about that and why you're doing that. Making handwritten changes in wills. This is very difficult. Sometimes when people have their original wills, they think, oh, I don't want this person to inherit anymore. I'll just cross out their name. But if you've got a formal will that was witnessed by two people and you just cross something out, does that make it a valid change? Maybe yes, maybe no, but you've opened up the door to potential litigation. So you want to be careful about making changes, that the changes you're making are valid and enforceable. So if you just cross it out, there's nothing else, it's quite possible the court will say, no, that's not a valid change. This was a formal will, you needed to have witnesses, you needed to have all the proper documentation done in order to make that change. So, but what you've done is opened up the door to potential litigation, because now we've got a person who's been apparently attempted to be disinherited. They've got an incentive to say that's not valid, whereas the people who weren't disinherited have an incentive to say, absolutely, that was a valid change. So we're just opening up the doors to more problems. One of the other major reasons you want to have a lawyer write your will is there's precise language in wills. Sometimes wills can be a little bit stodgy sounding, but there's reasons for those specific language. There have been court cases about what does and doesn't constitute a specific type of asset. If you have trust that we'll discuss a little bit further on, you want to make sure that you have the specific and necessary language included in your document so that the document that you're preparing is valid and enforceable and is also understandable. Plus, if your language isn't specific, if it's open to interpretation, if two people can look at it and say, I don't think that's what it meant, well, again, that's the potential for litigation, and litigation can cost you both time and money. Your estate can't be finalized because they're dealing with the fighting in the courts, and the only people making money are lawyers, which is probably not what you're intending with your estate. So another thing to think about when that your lawyer will discuss with you when drafting a will is the priorities for distribution in a will. You have to understand what the priority for distribution is going to be, or how everything's going to be distributed when you're writing the will. It's not just you put down a number of gifts. It matters in what order the paragraphs go. You can't give away something that you've already given away. So, for example, typically the distribution of estates is we start with debts. No matter what it says or not, you have to pay the debts first. Funeral debts, executor expenses, and estate expenses, then we have to pay taxes, then we have to pay legally enforceable debts. And after that, we start looking at the gifts in the will. Specific gifts typically go first, and then gifts of residue are at the end. So you have to understand in preparing your will that if you give almost everything away in your specific gifts, if you give away specifically your house and your investments and all sorts of things, then there may be nothing left for the people who are the residuary gifts or residuary beneficiaries. Also, one of the important roles that a lawyer does is they ask you to think a little bit further in the future, and sometimes about things that are pretty depressing and upsetting. And I realize that thinking about your own death can be pretty depressing to begin with. But you want to think about an alternative executor. What happens if something's happened to the person you've asked? What if they can't act because they're sick? What if they've predeceased you? What if they just don't want to act? I've had a few files where someone had named a friend at a point in time, and then 10, 15 years down the road, they're no longer in contact with that friend. Their friend has no interest in being the executor, and we're chasing that friend down to try and get them to renounce so we can appoint someone else to be executor. You want to think about alternative executors, alternative guardians for your children, alternative beneficiaries, and then you have to have specific ways of drafting that so that it's clear that they're an alternative beneficiary, it's clear that that's what your intention is. We had a will kit will in our office that had been signed by a fellow, and it ended up having about 18 beneficiaries, because what he had written in the will kit will that he had written in his own hand and had witnessed by 2 witnesses was he wanted to give his estate, the residue of his estate, to the following people: his 4 children, their spouses, and all of their children. And he had named everyone specifically. Now, looking at that will and how it was drafted, I have to wonder if, had he talked to a lawyer, if his actual intention was to say, actually, I want to give the gift to my spouse, to my children. If my children aren't around, then I want to give it to their spouse. And if their spouse isn't around, then I give it to the kids. Now, we were lucky in this situation in that these were long-term relationships and no one had broken up in the meantime. But if they had, it's entirely, those gifts to ex-spouses would have been valid, even if that's not what was intended. When we are drafting gifts to spouses of children or spouses of grandchildren or other family members, there's specific language that we use to make sure that if the relationship has broken down in between the will being drafted and the death of the testator, that people who aren't intended to inherit aren't inheriting. And finally, you need to think about a family disaster clause. Now, this depends differently at what stage of your life you're in. If you are a couple with 2 children or 3 or 4 children under the age of 18, you should think about a family disaster clause. I realize it's terribly depressing to think about. Your intent was to leave everything to your kids if something happened to you and your partner or your spouse. But if you're a family, you reside in the same residence, you frequently drive in the same car, you travel together, there's a risk that something could happen, a total family disaster where you are all die in the same incident or, shortly after each other. And so then you need to have a plan for what would happen then. Is your intention then that it could all go to your spouse's family or your partner's family? There's an assumption in law about the youngest person surviving longest. But really what you want to do is think, okay, well, if we weren't around, if we're all on the plane and the plane goes down, who would I want to have inherit? Would I want it to go to charities? Would I want it all to go to only one side of the family? Because that is a risk. So that's one of the things the lawyer pushes you to think about, okay, what's the next step in your will? This is so that it's a comprehensive document that will cover a number of different scenarios. So regarding taxes and estates, I said we're going to talk about this a little bit further because this is one of the major impacts on your estate that otherwise is not terribly well understood. So the way that taxes broadly work, and there are different scenarios, and so this is going to be a rough description of it, is that you are deemed to have sold all of the assets you own immediately prior to your death. That means that your final tax return, because you are deemed to have a tax year end on the date of your death. So January 1st to the date of your death is your tax year for the last year of your life. And all of your capital gains on all of your assets are going to need to be paid on that tax return. This can mean a substantially higher tax return and tax that has to be paid than most people are thinking of. This is not consistent with what your previous regular T1s that you've been filing for your employment or small business or sole proprietorship income are. It's going to be considerably more. Sometimes if people have significant assets, we're talking about hundreds of thousands of dollars. So it's important for 2 things. Number one, if you're executor, you need to make sure that you are getting proper tax advice in this case. And so that means getting a tax return prepared by an accountant or a tax professional. But that tax impact can really change what you're being able to leave behind to your beneficiaries, how much capital gain you might have on some of your assets or investments. So, a little bit more fulsome discussion of this. So, we've got the tax on the capital gains of all assets that you owned as of the date of your death need to be paid. So that's all property and that's all investments, including RSPs. Now, your RSP is something that people often don't think about. An RSP is tax deductible going in and almost fully taxable coming out. It can add substantially to your income. So what happens is the capital gain gets added to your income and your tax, so your yearly income includes basically this amount of your RSP. That significantly changes the tax perspective for your estate. Also, like we said before, you can have a named beneficiary on your RSP, but the tax on that RSP is paid in your estate. Now you're probably thinking, oh no, there's a withholding tax on an RSP. There isn't on death. if when you die, you have a named beneficiary, that RSP will be paid out to the named beneficiary without a withholding tax being paid. Now, if it's your spouse, it might be rolled over on a tax-free basis if you're a spouse or partner and meet one of the specific criteria, but otherwise, it's a payout. And that means that there's going to be substantial tax in your estate that has to be paid by your estate. So for example, you had 3 children, and one of your children predeceased you, but left some grandchildren, and you've named all 3 kids on your RSP and all 3 kids in your will with a gift over to your grandchildren in their will. What would happen is, because one of your children had predeceased you, their name comes off the RSP only goes to the other 2. And then the taxes are in the estate, which is what the grandchildren would inherit. So that can result in consequences that you really didn't anticipate. That probably is not what that person anticipated. It's not a fair sharing of the estate between the parties, but that is the impact, because they didn't get proper advice to say, well, you have to be careful with RSPs, because if someone dies, it doesn't assume it goes to their kids. The assumption is it goes to the other named beneficiaries. You also might have some exemptions. So for your house, you'll typically have the principal residence exemption for your house. If you own shares in a qualified small business, you might have a small business exemption, or if you have farm or fisheries properties, you might have exemptions for that. But again, if you have any of those things, you want to think about getting tax advice in advance. It's not just a matter of having the lawyer meet with you sometimes. Sometimes lawyers can say, okay, actually, I think you need to talk to your accountant about this, or you don't have one, we need to get you an accountant. It can be extra money up front, but it's worth it on the back end, because it can save money by having things properly set up, by making sure that what you're doing is fair and equitable and is actually what you intended to do. All right. So another thing that is difficult to address if you don't have a lawyer is a trust and a will. Now, a will in and of itself is a form of trust, because all of your assets are given in trust to your executor or personal representative, that they are going to do what you have asked them to do. But you can also have other types of trusts in your will. So a trust broadly is established where you provide your assets to one person, who is the trustee, to hold for the benefit of a third person, who is the beneficiary of the trust. Trusts can be a little complicated to draft. They require specific language, they require specific considerations, but it's very useful for people who either cannot receive their money right away or should not receive their money right away. So broadly here, we're thinking about minors, young adults, adults with disabilities, or adults with addiction issues. So for children, a child cannot legally inherit their money until they're at least 18 years of age. That means that their money must be held in trust by a trustee. If the will doesn't specifically set up a trust for any minor children, then the public trustee's office will hold that money in trust until that child is 18 years of age. In that estate I spoke of earlier, where the fellow had named all of his children, all of their spouses, and all of his grandchildren, as it turned out, some of those grandchildren were minors. So now we have to get the public trustee involved, and the public trustee is going to have to hold on to that money for them until their 18th birthday. Now, the other difficulty with that is that that means that child is receiving the money on their 18th birthday, which may not be the life lesson you want to teach them about the future. Even the most mature and responsible child, 18-year-old, is probably going to be thrown for a loop with a lump sum of money. It's not ideally what you want to teach them about how the rest of their life is going to go, because they probably will never receive this lump sum again. With a trust in a will, and with a lawyer drafting a will, you can draft a trust. Say, okay, actually, I want it the money held in trust until they're a little bit older. Maybe you want it held till they're 21 or 25 or 30, depending on how big the share is. We can also set up what we call a staggered trust. So you could say, you know what? I don't want them to have nothing. I just don't want them to have everything right away. So maybe we'll give them some at 21. Maybe we'll give them some at 25. maybe we'll give them the rest at 30. You can set it up with a couple of different times for distribution. And the benefit of that is then you can give them a couple of times to grow and mature, a couple of kicks at the can, so to say, that if they make bad decisions when they're 21, they haven't blown the whole of their inheritance because some was held back, and they know, okay, I've learned from my experience, I'm not going to do that again, no matter how much my friends think it's a great idea for me to get a brand new car and that I now have to buy all the drinks at the bar, that no, I don't have to do that. I'm going to save because, boy, did that money go a lot faster than I thought it would have. You can also draft, when a trust is drafted properly with legal advice, draft it so that there's some flexibility. So we're talking about what we call the power of encroachment to the trustee, so that the trustee has the ability perhaps to release money early if they think it's necessary, perhaps release money to the child or their guardian for proper maintenance and support or any other specific reason. Sometimes we want to give consideration to the fact that while we want to reserve the money for the child when they're older and more mature, and we want to reserve it for them for their future, we also want to make sure that the circumstances they are in right now are not poor and that they are still receiving as much benefit and education as possible. And maybe it's necessary to release money early to ensure that they're getting the best education available and the best life experience available. So trust for adults. We can do similar things in trust for adults. Sometimes even because someone is 18 years of age doesn't mean, as I said, it's a good idea to give them a lump sum of money right away. Sometimes we want to think, especially for higher value estates, about waiting till people are 25, 30, 35. 40 is really my absolute maximum. I don't like doing trusts over age 40 because frankly, my opinion is you don't usually do a ton of maturing after age 40. That's usually as mature as people are going to get. So they're either going to be as good as money as they are at age 40 or not. But it does allow a little bit of control. And again, even when you have young adults who are inheriting, that again, they're not being given everything right away, that if they make a couple of poor choices, that's not the end of the line for their inheritance, and we can reserve some back for the future. When you're dealing with adults with disabilities or with addiction issues, we think about something, a lawyer will often suggest something called a discretionary trust. And these need to be very carefully drafted. But the idea of a discretionary trust is that it allows the trustee discretion. The trustee holds all of the assets, they maintain it, but it allows the trustee discretion to make payments to the adult when necessary. So this can be done for someone, for example, on AISH to ensure that they are not being given so much money that it knocks them off their AISH benefits, and so that we can maximize government benefits and reserve as much money as possible for the future when their medical expenses might increase and when they're no longer have AISH support and instead on CPP and OAS, which, as difficult as it is to say, it is not as generous as AISH. So, and typically the expenses are higher, so we want to think about reserving money for that later period of life. But again, just making sure that they're getting the maximum benefits available. Also for adults with addiction issues, sometimes there are family members for whom receiving a lump sum of money will only encourage risky behavior or might lead to circumstances that the person giving the gift does not intend. And so you can draft a discretionary trust so that, and you can talk to your lawyer about how to draft that and who to name as a trustee and how to set it up so that they're not receiving a lump sum of money, which may inflame some of their addiction issues. So broadly, why do we suggest you get professional help? Is one of the major reasons is to avoid your beneficiaries in your estate paying litigation lawyers a lot more money in the future. If litigation can be avoided, litigation can be avoided oftentimes if we're drafting properly, if we're thinking about who your potential claimants are, if you're having that discussion with the lawyer to say, well, what's the tax impact? Who might potentially have a claim against my estate? Who might, what claims do we think we see coming? Sometimes there are claims that my clients don't see, but in a discussion with me, they're thinking, oh, I didn't think about that, but that's a possibility. And we can draft around those possibilities, or we can make a plan for that possibility so that, okay, if that happens, here's what we do then. Sometimes litigation cannot be avoided. And in that case, having been to a lawyer, the lawyer's file can be an important resource for the estate in saying, well, yes, this is what the person intended. This is the discussion they had with their lawyer. This is what went on. This is why I think this is valid. Also, you're a third party who doesn't have an interest in a specific beneficiary typically. That's the witness, and that's always to a benefit. The tax consequences factor is quite significant. To avoid undue tax consequences, to make sure that you've planned for the future, make sure you're not disadvantaging one beneficiary because you didn't understand how some taxes might inform things going forward, that can be a huge benefit to your estate. And most importantly, seeing a lawyer ensures that your will is valid, and it ensures that it reflects your true intentions. I just recently had an estate where the person had done a will-kit will, but the will wasn't actually valid as he drafted it because he didn't have any witnesses, and a will-kit will has printed material. So as we said before, if there's any printed material, that's a formal will. You need 2 witnesses. Luckily, in this situation, we were able to look at one of the pages. He had signed and dated every single page, which was good. And there was kind of enough there that I could cobble together an argument to the court to say, okay, well, didn't successfully appoint an executor, so that's extra work we had to do, and did successfully do a couple of other things, but he did kind of tell us how he wants to distribute his estate. And so we could go to the court and make an argument to adjust around that. But that's extra time, that's extra cost. And instead of the estate being able to start from the ground running going, okay, so we've got a lot to do, here's my executor, they're appointed, we have to go through extra steps. We have to get people to sign consents, we have to make arguments to the court, and that costs time and that costs money. And for an estate, time is money, because if you have a house you can't sell, if you have a condo you can't sell, or you can't deal with any investments, maybe you want to divest of assets, maybe you don't want to, but that's causing money that there can be losses to the estate, there can be losses to the beneficiaries as a result of that. And so one of the best benefits of seeing the lawyer is ensuring that your will is valid and that your true intentions have been captured.
Well, I want to thank you very much again for your expertise, your insight, your examples. I think everyone has learned a lot. I know I certainly have. And so again, Anna May, thanks so much for everything. To all of our listeners today, thank you so much for coming and listening in. And I will sign us off now. Have a great rest of your evening, everyone. Thanks. Bye, Anna May.